Tractate Bava Batra, page 132. Pleasure to have you here, and it's a great feeling to know that so many of you watch worldwide. Here we are in New York, and we are going to discuss the subject of apotropos and the writing of different variation of inheritance, and obviously all kind of consequential evidence that lead us to rule when it's come to a steward or guardians in different ways. We differentiate between a person who is in a total mindset of healthy versus a person in a deathbed. We're going to elaborate on a subject that we talk in the past a lot, which is the difference between a gift during a lifetime versus a total structure of inheritance. But let's start in 132, the top of the page. Ba'ei rava bevari ei ach. Here we continue the subject of a man, basically a healthy person, that granted to his wife the right to be the executor or steward on his estate. Let's understand, we have to differentiate between, in the modern days, changing titles of ownership between two people versus appointing individual to be in charge, to be the executor. Here, the question is, what is in his mindset when he does that? We assume at the first glance that he wants to gain respect to her, meaning obviously people who live don't think much about what happened after they're no longer among the living. People do not like in general to discuss or to think about it. But here we have a situation that he wants to make sure, not only after he is gone, but even for this very moment, to make sure that the children give her the proper attention and respect. And therefore he appointed her during his lifetime to be executor, and he did which called ma'aseh kinyan, a manner of acquisition. So here we discuss what exactly the situation. We understand when we talk about someone who's about to die, he's in a deathbed, and he wants to make sure that the children will listen to her. So therefore he make her in a way the one who's a executor. So that's understandable. Aval bevari haka'e ihu. When he is healthy and obviously they respect her because of him. So what's the purpose? So or dilma, or you go the other way around. Bari namen yichaled lishtamun milei me'ashta. He has his own cheshbon, his own account that he figured out. If he appointed his wife to be executor or steward, they are going to show extra respect in advance. It's like someone talked to me the other day about politicians here. So I said to him, it's 2 years from now is election. So he said, you never know, it's good to keep in touch and make connection because you never know how things turn around. So in a sense, he wants them to show respect to her at this very moment, and therefore the Rashbam explained, he structured it in such a way. תשמע כותב פירות נכסיו לאשתו, גובה כתובתה מן הקרקע. If someone writes a document that the profits of his property should go to his wife, in the event that he dies or divorces her, she collects payment of her marriage contract, which he wrote her at the time of their marriage, from the land itself. So the profits are her as a result of his gift. הכותב פירות נכסיו לאשתו גובה כתובתה מן הקרקע. Because in a way, when receiving matana, when receiving a gift, the big question is if she let go the shi'abud ktuba, the whole idea of his commitment toward the marriage agreement. למחצה, לשליש ולרביע, גובה כתובתה מן השאר. If, as we discussed earlier, it's in a part, which is he appointed the state for a size of a half, 1/3, 1/4 of his property. She collect payment of her marriage contract from the rest of his property, which he did not give her as a separate gift. So all of that we in a way understand. Obviously the Rabbeinu Gershom and Tosfot go a little different. We just go by the Rashbam explanations. That we are dealing here with a total ownership of part of his estate, and she still hold rights over the Ketubah. She didn't relinquish her rights from the Ketubah. כתב כל נכסיו לאשתו ויצא עליו שטר חוב. However, if it's a situation that he put all of his estate to his wife and subsequently a promissory note emerged against him for a loan he took while they are married, but before he gave her the gift. So here, when she received in general structure all the estate, we still have Shi'abud Ketubah. But the question is, who take precedent before the others? Why? Because if you go by the process, you have the Ketubah, and then you have the marriage, and then you have the loan. But the question is, now when it's come to collection, the Baal Chov, the creditor, said that I should get first. She said, since she was the first one, she will get first. Rabbi Eliezer Omer, תקרא מתנתה ותעמוד על כתובתה. Rabbi Eliezer said that she should tear up her deed of gift and remain with her marriage contracts, so the creditor will not be able to collect the property she received as her marriage contracts preceded the promissory note. As we explained, let's make sure we understand. First they got married, so she have the ketubah, the marriage contract, and then he took a loan. Now she have the promissory note and you have the creditor. So if she is tearing her ketubah, basically she is the first right to preceding the creditor. If not, then the creditor said, look, you get gifts. It's very nice you get gifts, but here owe me money. So as much as you have very expensive or valuable gifts preceding later on, you create here a conflict. So even Rabbi Eliezer hold that even the wife receive all this estate as a gift, she never let go, relinquish her rights over her marriage contract. Why? Because she is concerned that her gift will be abrogated because it's a lien against it, because there is a creditor that owes money. So therefore, since the Shi'abud Ketubah, the money owns for her Ketubah, it still existed, that take precedent. והחכמים אומרים תקרא כתובתה ותעמוד על מתנתה ונמצאת כרחת מכאן ומכאן. The sages said, look, if she basically turned the ketubah and she stand to receive the gift, the problem is this guy is coming and collecting it, and guess what's the result? It's lost in both ways for her. The sages hold that when she received a gift, a wife received a gift from her husband, she didn't figure out that there is a possibility creditor can come in and collect it from that. So therefore, when she relinquished her rights over the marriage contract, she basically lost in both ways. She lose everything. ואמר רבי יהודה, נחתום מעשה ואירע דבר בבת אחותי כלה. So he said that a situation like that happened to my sister daughter, who is my daughter-in-law, that my son wrote such a document to her. So basically the daughter of the sister of Rabbi Yehuda Nachtom, she married to the cousin, and the husband gave her all his estate as a gift, and then a creditor came, creditor that the husband owes money, and he wants to collect from the estate. ובא מעשה לפני חכמים ואמרו תקרא כתובתה ותעמוד על מתנתה ונמצאת כרחת מכאן ומכאן. So they came before the sages, they said that she must tear up her marriage contract and remain with the deed of gift, and she found to be bold from here and from here. So Tama, the Yatzarav Shtar Chov. Because the creditor comes in and prove that what the husband owes him preceded the gift that he gave to his wife. Hal lo Yatzarav Shtar Chov, Kanya. But if it wasn't any lien that preceding to that gift the husband gave to his wife, so basically the wife acquired this estate. Ubemai, and what exactly the Braita speaks about. So if you tell me that you are talking about a person who is in his deathbed, that was the period of time that while he was in a deathbed he wrote his estate to his wife. So you have the issue, ve'amart lo asa ela apotropos. You said that he make her only what? He make it as a steward, as a executor. He doesn't meant to give her the right to acquire her. Big question that we should ask, if that make her, all this process make her to total mechilat ketubah or not. Is a Ritva and Ran and Mukhe Yosef that are dealing with us. But anyway, so the Elalav Bebari, you have to speak about person who is total healthy, that he wrote all of his estate to his wife, and she basically acquired the estate, not only being a steward. So Gemarrah rejected that and said, Le'olam bishchiv mera. You have to say that this is about a person who is really in his deathbed. And so in short, most of the Mefarshim say that it's not a contradiction here between the two. They basically hold the same idea. The Rimigash and others hold that it's a correlating the two. It's just different structure. One speak about Bechulhu, when they use this term, which is the wife acquires the property and is not appointed as a steward. And Ravina hold that it's what he wrote the document granting all of his property on his time of about when he betrothed his wife or his divorcee, his former wife, and where he concedes that she acquires the property. Now, I would like to share with you a Rambam before we continue. The Rambam tells us, and this is the Hilchot Zchiyah Matana chapter 6. If a healthy person writes a document granting his property to his wife or son or other people detailed in a Gemara, the recipient is rendered a steward with regard to the property. As in the case of the person's deathbed. It's because this Rava's dilemma was not resolved and the other heirs have the presumptive right to the property. So as you see, one of the things that in the Choshen Mishpat 246 discussed that this is unresolved issue. So Amar Rav Yosef בר מניוני אמר רב נחמן, הלכה תקרא כתובתה ותעמוד על מתנתה ונמצאת כרכת מכאן ומכאן. So usually the Rashbam said usually יחיד ברבים, הלכה כרבים. But here he needs to say that they follow halacha according to the Chachamim. And you see the Rambam in Hilchot Zchiyah Matana chapter 6 said, if a wife receives all her husband's property as a gift, she loses her right to receive payment of her marriage contract. Therefore, if a promissory note that is dated prior to the gift emerges against him, the creditor collects the debt from the property and the wife does not receive payment of the marriage contract or the gift. Basically, that's the view of Rav Nachman. This is due to the assessment that she presumably intended to waive her lien on the property in exchange for the benefit she derives from the public knowledge of her husband's gift to her. The Rashbam notes that if he later acquires the property, she receives payment of her marriage contract from the property. Now, it's important to know the Rosh here in Siman Lamed Bet in chapter 32 said that the Baya is not Nifsheta and is not Kontash, is not Hevet. But you see that the Ksod HaChoshen in Reish Nun that it's all a problem with safek umdena. It's called dvarim shebalev. It's thing that is in the heart of a person. That's therefore that's the reason it's not kana. You see also Baliyot Rabbeinu Yoina in Kuf Memched that he said the same idea. I heard a question from the great Rab Gershon Edelstein. He said that this is basically safek umdena. So why you don't consider dvarim shebalev? Why the Rosh hold it sinakanta? You bring the Chidushei Aran and Ritva, and obviously is above the scope of our discussions. But if you want to read more, my brother-in-law, Rav David Avram Mandelbaum, in his book Daf al Daf, elaborates a lot on this Ktsot HaChoshen and on these questions. Anyway, Lemeimra de lo azil Rav Nachman batar umdena. So basically Rav Nachman do not go by the assessment of people, so he will bring a case, painful case. הרי שלח בנו למדינת הים ושמע שמת בנו, ועמד וכתב כל נכסיו לאחרים, ואחר כך בא בנו מתנתו מתנה. So there's the first notion view. Imagine a fellow that his son traveled overseas, and unfortunately he heard the wrong news, but he heard the news that his son is no longer among the living. So he went ahead and he wrote his estate to strangers. And then the son came back. So the problem is, you can argue and say that it is in a way a gift. Why? Because he didn't spell out when he gave the gift that he is doing so because he's thinking that his son is dead. רבי שמעון בן נהסיה אומר, אין מתנתו מתנה שלו, יודע שבנו קיים לא כתבן. So this is a make it out of sense, a rational idea. He says his gift is not a valid gift because obviously if that fellow knows clearly that his son is alive, he will never do that. He never. So basically he'll go by umdena, by assessment. ואמר רב נחמן, the Rav Nachman is well known head of court, he said, הלכה כרבי שמעון בן מנסיה, because you go by the umdena of people. So the big question is, if that's the case, why you don't do it here? So here we try to solve that is not a juxtaposition between the two. Why? Shane Hatam, when a person writes all his estate to his wife, and all of a sudden you see that there is a shtar chov, that is a promissory note of owning the nichale de lipokara kala, the chadvinu niala la'anu nechasim. She basically, it's good in her for her reputation or for her publicity that he granting her all of his property, and she was willing to risk not receiving payment of her marriage contract to gain these benefit. Now, it's important to know the view of the Rambam. The Rambam again in Ilchot Zchiya Matana chapter 6 said, if one's son went overseas and he heard that his son died and he wrote a document granting all of his property to another as a gift, and then his son returned, the gift is cancelled, as it is assumed that the father will not have given the other all of his property had he known that his son was still alive. Basically that's the follow the Rav Nachman, which we just said, and that's follow Rabbi Shimon ben Nasya. If he left some of his property out of the gift, so then the gift stand, and that's basically the Choshen Mishpat in 246. Now we're going to a different direction. Again, the big question is, since we talk about a person who Shchivmira was in deathbed, so the Rashbam said we also talk about a person who is in a good health. Tnanatam, this is something we learn in the Mishnah in Tractate Bava chapter 3, Mishnah number 7. הכותב נכסיו לבניו וכתב לאשתו קרקע כלשהו איבדה כתובתה. If a person write a document and granted to all of his to his property to his sons, and he wrote a document granting an amount of land to his wife, she lost the right to receive payment איבדה כתובתה for a marriage contract, because obviously that applies solely, Rashbam said, to those estate that was given to the son. But other estate that the husband purchased after they are together, obviously she can collect it. That's also the view of the Rambam. Now, the Rimigash challenge that. But anyway, משום דכתב לקרקע כלשהו איבדה כתובתה, because he wrote some amount of land, she lost the right to receive payment for a marriage contract. Why? There's three explanations. Number one, המרב במזכה להן על ידה, that he transferred the ownership of property to his son. So basically, it's giving sudar, kinyan sudar, and basically they use kinyan khalifin. So she helped her husband to do these transactions to his son. So it means that she agreed that the sons will receive as a gift the estate, and she will not have any lien on them. Number two, Shmuel אמר מחלק לפניה והיא שותקת. Shmuel hold the story is that he distributes the property to his son in her presence, and she is silent and does not ask about her marriage contract. So the idea of Shmuel is you don't need her to be part or to help of this matter of possession of the estate. That's the way of the Rashbam. Baal HaMaor challenged that. And the third view is Rabbi Yossi ברבי חנינא אמר, ואומר לה תלי קרקע זאת בכתובתך. So she kept quiet while he said to her, take only this parcel of land for your marriage contract. So basically by being akuyas, so or even according to other meforshim like Ritva, even the Rashbam mentioned that if she wasn't present there, so it's part of that agreement. Rabbeinu Yoina and Baal HaMaor disagree, but that's the way the Rashbam and Ritva said. We assume that she agreed and she let go, relinquish the lien over other estate. Page 132b, umikulei ktuba shanukan. So this, one of the leniencies applied to a marriage contract. So first and foremost, it's important that this is not one of the explanation of those three, the one we mentioned earlier, neither Rav Shmuel or Rav Yossi ben Chanina. It's important to those who read Hebrew to read both a Pnei Shlomo, Rabbi Elchanan Wasserman, and a Shiur Rabbi Shmuel. I would like to start with Rabbi Elchanan Wasserman. He brought Mordechai. Mordechai said in his days it was a situation, someone divided his estate, he put part for tzedakah and part he gave it to his children. The problem is the children get bankruptcy for misconduct their afterward businesses, and it was very bad. And the thing is, it was a question if they allow, in order to survive, to touch the money that the father dedicated to tzedakah in advance. So the Elchanan Wasserman bring the Mordechai. He said that that when it's come to tzedakah, when a person gives before he is passing the tzedakah, he called it pachad adin, the fear of the afterlife judgment, and that's what we call ve'alach lefanecha tzidkecha, that the malachim, it's believed that after burial, the angel of that came out of the mitzvah of tzedakah, basically protecting the soul. So therefore, we assume that that was the immediate. And since after passing the distribution of the estate was later, so therefore the tzedakah was pre-dedicated, and in a way it's not belonged to them. They it's like not existed. That's the notion. Again, Rabbi Elchanan Wasserman brings from the Mordechai. But another phase here, which I think it's important to see both Ritva and Pnei Shlomo. I would like to read to you something that my dear friend Rabbi Steinsaltz wrote in the Koren Gemarrah. I'm just reading the translation. He wrote it beautifully. Just few lines. He said here, he brought the Ritva obviously, and he said, the ruling of the Mishnah that the wife can lose her right to payment of her marriage contract in this manner, as one who gives property to his creditor as a gift, is not exempt from repaying the debt. Another leniency, that's basically the Rashbam, applies to a marriage contract is that whether a standard creditor collect the amount on him from a Beinonit, as we said, there's a three level of karkaot, the middle one is Beinonit, for an intermediate quality land. A wife collects from inferior, the Ziburit, inferior quality land. The reason that these leniencies that as opposed to a standard creditor who perform a favor for the debtor by lending him money, women generally want to get married not less than men. That's a famous Gemarrah in Ketubot 86b. Since there is no need to impose conditions upon the collection of the marriage contract to encourage marriage, payment of a marriage contract is treated more leniency than a standard debt. But here the Gemara challenged these three different explanations. Tanan, we continue with the Mishnah. They said, Rabbi Yossi Omer im kibla aleha. If the woman, she accept upon herself to relinquish the right of shi'abud ktubah, the right, the Rabbeinu Yonah and the Ran said that she said it in such unambiguous, lucid, clear way. She said that she relinquished her right for the estate that was given to the sons. Afal pi shelo katav la ibda ktubata. Even the husband did not wrote for her any estate. She lost the right to collect the ktubah from those estate that was given to the son. So it means Rabbi Yossi disputed the first Tana of the Mishnah, and what we derive from Rabbi Yossi, Michlal de Tanaka Masavar Ktiva veKabbala Bae, which means he hold that you need to have both. You need to have the writing a document that granting her a piece of land and acceptance of the distribution necessary for her to lose her right. That's basically the opposite to what the Rav Shmuel and Rabbi Yossi Ber Chanina said. So because all of them assume that she need affirmatively accept the distribution and her act of silence is sufficient. And that's something that we explained many times. Display equanimity or being acquiesce or silent can interpret it in that notion as a total agreement. We always, I was a rabbi of two congregations. So how do you say it? Fortunately, unfortunately, for about 2 decades, I attended to those board meetings. So sometimes people said, Rabbi, if you are quiet, people interpreted that you agree to what was saying here. It's a problem, right? If you tell me that it wasn't any disputation between the two bavot, but both of them followed the view of Rabbi Yossi, which means that this Amoraim, the Rashbam said, come here to interpret the first clause of the Mishnah, which means it's enough to have independent writing in order for the wife to lose the right of collection of her ketubah. When we said that the first ruling of the Mishnah applies, Shaita Sham, that the time that the sons have this estate, vekibla aleha, she accept upon herself to let go the shi'abud, aval hayta sham velo kibla alea, or kibla alea velo hayta sham, lo ibda ktubata. So basically, tuvta dechulu tuvta. There's a total refutation to all. Now, the thing is, Tosfot bring the notion here that Rabbi Yossi disputed, and he hold that is enough part of that, but we do not have time to go for this Tosfot, and I recommend those who have the time, please visit this Tosfot. It bring another light to understand this sugya. But anyway, Amar l'Rava l'Rav Nachman, Ha-Rav, Ha-Shmuel, Ha-Rabbi Yossi b'Rabbi Chanina, which means the interpretation, the first one, which is the Rav, that he hold that it was Mezakeh lahen al yada. That's the form of kinyan, by her. Or Shmuel said, Mechalek lefanea v'hi shoteket, that he distributed and she was quiet. Or, according to Rabbi Yossi bar Chanina, he said that take this estate, tli karka, take this estate, zu, specific karka, b'ktubatech, in exchange for the ketubah. Mar ma'isvir alei, what we hold. אמר לי רב נחמן answer to רבה שאני אומר כיוון שעשה שותף בין הבדים מבדה כתובתה. The moment he makes her another partner in the property among the other sons, she lost her right to receive payment of her ketubah, of her marriage contract. So Rashbam have a few explanations how to understand it, but the Rif and the Rosh, You see also in the 2 Ibn Ezer 106, if a person on his deathbed wrote or said, that's basically called the Chilkat Mechokek said that all of his property is given to his children, and wrote a document granting any amount of land to his wife as well, if she found out about it and did not protest, she has lost her right to receive payment of her marriage contract through not of her dowry. That's basically the Rema bringing the Magid Mishneh, as she become partner in the inheritance. This is according to the Rosh interpretation of Rav Nachman's ruling, which is based on several factors. That if the husband gives a wife a parcel of land, her explicit acquaintance is not required, meaning by being acquiesced, in according to Rabbi Yossi's opinion, that her presence during the distribution is not required, contrary to Shmuel's opinion, and that the husband does not need to tell her that he's giving her the parcel of land for a marriage contract, contrary to the opinion of Rabbi Yossi, son of Rabbi Hanina. You see also the Ilchot Zchiyav Matana of the Rambam, chapter 6. By Rava, bebari ei ach. So here Rava bring a question that we didn't have any form of discussion earlier, which is a healthy person writes his estate to his children, his sons, his wife, etc. So it means, even in the case like that the person is total healthy, Rabbi Yossi hold that the fact that she was quiet, it means that she relinquished her right, mochelet shi'abud nechasim, that was given to the son or not. So now we elaborate on this predicament. Mi amrinan, do we say in this dilemma that specifically b'shchiv merahu, that the person was a deathbed, then she lost her right for those estate. Diad'a deleitle v'kamachala. She know that he had no other property and nevertheless waived payment of the marriage contract. However, aval bevari. However, if person is a healthy person and she is quiet and she is not protesting, savra hadar kanei, she hold that, guess what, that he will then acquire other property for which she will be able to collect payment for a marriage contract, and that is why she accepted the distribution of the property. O Dilma, the Yad Ramah have a little different view, but we go by the Rashbam. O Dilma, so another side of this quandary, of this predicament, O Dilma, even in the situation of a person who is total healthy, hashta mihat leitlei. But now, because there's no other property, her acceptance should be interpreted as waiving her right. So the Gemara said, Teiku. So first is the Rambam. He said in Ilchot Zchiyav Matana chapter 6 that if a healthy person distributed his property to his children and wrote a document granting his wife a parcel of land, the halacha is that she lost her rights to receive payment of a marriage contract. That's basically, you see in Ibn Ezer 106. This is because Rava's dilemma was not resolved and the property cannot be appropriated for the heir during the uncertainty. Now the truth is there is a machloket rishonim what exactly the meaning here of the teiku. This is the unresolved. Is that really teiku or not? But here the Gemara brings three stories that connected to that ruling of the Mishnah. I'll just go to the first one, that quickly. Okay, Hauda Amar Lehu, here it's a person that is on a deathbed, about to die, and he has two daughters. And he said to people around him, Palgali brat vetilta liitat pefirei. He was what I'm doing. I'm taking half of my estate and give to my oldest daughter. Let's call her name. The oldest daughter, let's call her Tanya. So he's giving to Tanya, he says, half of my estate. Upalgali brat, he have another daughter called her Esther, so he gave the second part to the other daughter. Vetilta leitat befirei, and he has this produce that come of the trees that he owns, so he give 1/3 of the produce to his wife. Ikla Rav Nachman lesura, so Rav Nachman reached the point of the city of Sura. So Rav Chizda, al legabe Rav Chizda came to visit him. Amar le, Rav Chizda said to Rav Nachman, ki hai gavna mai, meaning, how do you treat the situation that the person did not wrote to his wife a parcel of land, only produce? What exactly the rules? Did she relinquish her right over the estate? Or because the husband make her a partner among his daughter in the distribution of the produce? Or because he did not make her a partner with the parcel of land, the gufa karka, therefore she's not relinquished the shi'abud. Amar lei, Rav Nachman said to Rav Chizda, hache amar Shmuel, afilu lo ikna le dekel echad leferotav. Even he gave her the right, Rashbam said, to eat the produce of one of the palm trees, even those produce are not there yet. Ibda ktubta, she lost her right to collect money for her ketubah. Amar le Eimud, amar Shmuel atam, de'akne le begufa de'ara, hacha peirau. How come you can differentiate between estate, land, but here he only gives the produce, so without any share of the land itself. Perhaps she does not lose payment of her marriage contract. So Nachman respond, and he said to him, Amar le mitaltelei ka'amart, mitaltelei vadai lo ka'amina. Here, when you talk about movable property. So I mean to say that she's not going to lose the right that he gave her of a movable property, such as a produce. The whole idea is she received payment of her marriage contract, and the whole concept is that he thought that we talk about attach perot mechubarim. Because if you talk about perot tlushim, if it's detached produce, it's clear that she is not mochelet, she is not relinquish her right.